Hello and welcome back to this channel. It is hump day, and it is a big day today, December 3rd. Okay, y'all are gonna probably get sick of seeing my face, but I hope not. My name is Mandy Magnan. I'm an actress, writer, producer, and director in Toronto, a movie reviewer, pop culture, and your YouTube commentator for everything it ends with never. There's gonna be a bunch of stuff coming at us today, and I'm gonna try to make each video condensed 1 to 2 topics per video so we can get through all of it. So today in this video, this specific video, what we're going to be talking about is the schedule. So I'm going to show you what to look forward to. It's already been posted in Court Listener as well as Popcorn Planet. Yes, Andy Signor, bad news for him yesterday coming out of the courts, and we're going to go through that whole motion. You're going to need an emotional support something, okay? So grab your emotional support lip gloss. You are in frame with Mandy Magnan. This is a nice little schedule that was posted by Blake Lively yesterday. It was submitted into the court just, I guess, to remind the judge of everything that's going on. But it's great for us because now we have the full timeline of stuff. So we're just going to go through it right away. There is a court hearing on December 9th for all parties. That will be very interesting. But basically, she just wanted to bring to the attention to the judge the case management plan and scheduling order. So thank you so much. It does say that it's from all the plaintiffs, so that's good. I guess they just want everything clean, clear, and concise. So here we go. So today, this is what we're anticipating. Lively's opposition to the Wayfair party's motion for judgment on the pleadings. Jones Works' opposition to Abel's motion for summary judgment. Blake Lively's opposition to the Wayfair party's motion for summary judgment. Also, the Wayfair party's opposition to Lively's motion to compel. Tomorrow, we're waiting on the Wayfair party's substantive response to Lively's supplemental Rule 11 letter. On the 8th, Lively's reply in support of her motions for spoliation. Also on the 8th, Jones Works' reply in support of motion for spoliation. Then on December 12th, that will be the last day for expert discovery. On December 12th as well, the Wayfair party's reply in support of motion for summary judgment. Also on the 12th, you have the Wayfair party's reply in support of motion for judgment on the pleadings, as well as Jennifer Abel's reply in further support of her motion for summary judgment. Then on the 19th, that's like the last to-do of this year so far. On the 19th, we'll have motions for continued sealing of material submitted in connection with 1, the Wayfair party's summary judgment motion, the oppositions and replies, and then 2, the opposition and replies to Lively's motion for spoliation sanctions, and 3, Lively's supplemental letter motion, Rule 11, oppositions and replies. Also on the 19th, we have motions for continued sealing of material submitted in connection with Abel's summary judgment motion, the opposition and replies. That's what we need to know for at least this year. There are some outstanding motions that we should be looking at because there will be replies from the judge, orders for these, and there is a lot of things outstanding. There's Lively and Reynolds' respective motions for sanctions, Leslie Sloan and Vision PR's motion for attorney fees, Lively's motion for sanctions pursuant to Rule 16F and New York Rule of Professional Conduct, motions filed by non-party J. Alexander Townsend, motions for sanctions pursuant filed by non-party Mackenzie Folks. And Mackenzie, girl with the spatula, she's actually one of my favorite creators. I love her deep dives. Lively's motion for attorney fees, treble damages, and punitive damages. The Wayfair party's motion for judgment on the pleadings. Lively's motion for spoliation sanctions. Jones Works' motion for spoliation sanctions. Lively's motions to preliminary seal filed in connection with sanctions. There's a whole bunch. As you can see, there's a lot of things that the judge needs to still rule on. I mean, there's a ton of things here. So we should see some of those orders coming through probably, I would say, even after December 19th or sometime in the new year or even in the next week or two. I mean, they do have their meeting with the judge on the 9th of December. The status of discovery. Fact discovery is complete. Although Lively's filing motions to compel, fact discovery is complete, okay? The parties anticipate that expert discovery will be completed by the court order deadline of December 12th. Settlement discussions. The parties have nothing to report regarding the status of settlement negotiations at this time. Okay, I guess there is no settlement talk or they have nothing to report at this time. So that's very interesting. Anticipated length of jury trial. The parties agree that the case should be tried to a jury based on the substantial evidence adduced in the case to date, Lively anticipates the trial will take 3 weeks. The third-party defendant, JonesWorks, requests that the third-party claims be bifurcated and tried separately after the main action. JonesWorks anticipates that a bifurcated trial of the third-party claims will take 1 week or less. And bifurcate is, I looked it up, y'all, because I was like, what? How do I say this? It is divide into 2 branches or forks. So she wants hers obviously tried separately. There's a lot more going. It's just separate action. So she would like hers tried separately, which I already thought was going to happen. But hey, the Wayfair parties will oppose any motion by JonesWorks to bifurcate, assuming all claims in Lively's second amended complaint and Abels' cross-complaint against JonesWorks remain for trial. The Wayfair parties anticipate that trial will take 4 weeks. So we'll see if it even gets that far, because the judge, I'm guarantee he's going to dismiss some of Blake's claims, because the summary on the pleadings and the summary judgment was so good. Okay, I mean, we're still waiting for her responses now, but I don't see all of her causes of action going to trial. The summary judgment and other issues, the Wayfair party's motion for summary judgment and for judgment on the pleadings are pending. Abels' motion for summary judgment on her claims against JonesWorks is pending. As of right now, when I make this video, there is still nothing yet from JonesWorks or from Blake Lively that have been filed. Okay, so we're still waiting. And I would just guess that it's probably going to come in at the last hour. I'm just assuming that it probably won't be filed till later tonight. But hey, I would love to be wrong, and I love a good surprise. So drop those files, Blake. Okay, drop them like they're hot. Okay, big news and heartbreaking news yesterday. Yes, Andy Signort and Popcorn Planet was denied their motion to quash, and the ruling is quite spicy. I was like just heartbroken reading it. It seems like, in my opinion, super biased and not quite like the judges up to the times. You know, it seems like a really old school mentality that he has, or she has, that they have. I didn't look into if it's a guy or girl. Sorry. That they have. So we're just going to read it, and I'll let you decide on your own. But here it is. This is the order from the judge yesterday denying Popcorn Planet's motion to quash. Wowzers, court listener is down. Okay. Let's, all the wheels are spinning. I can't get to Jen, Abel, and Jones. I can't get to Blake Lively and Wayfair. I can't get to Popcorn Planet. I can't get to nothing. Okay, we'll just wait here for a moment. Let's see what happens. While we're waiting, I just wanted to bring up this comment from Cat Bravo 994, who said, they are going hard against Popcorn Planet. They sued them to get every bit of info he had on his upcoming documentary on Blake Lively and Justin Baldoni. I imagine they want additional time to see what they can get from them. They don't have enough against Justin Baldoni, so they are suing people for info and phishing or anything they can use against Justin Baldoni. Sickening. If there really was SH, then you should have had that before you file. Not file, then try to get the info to fight him with. Surprised she isn't suing people who comment about them. Yeah, dang. I totally agree. Thank you for this comment. And yeah, it's pretty wild, the entire situation. I feel like if Megan Twohey from the New York Times can get away with it, then what? Then why can't, Popcorn Planet? I just think, what's the difference? Except now it's on the internet versus publication. That's why I think the judge's ruling is a little bit old school minded. And also I feel like what they're trying to do right now, and I saw someone on Twitter actually tweet this, is they want all of this information because any of the cast and crew who did talk to Popcorn Planet, Ryan Reynolds will have their names now and all of their information, and I guarantee he will do whatever he can to blacklist them in the future. It's a huge breach of privacy. I think it's totally, oh my gosh, I'm just like really against this ruling. What's wild is this is what I'm getting on every single court listener tab. I had all of the tabs up. I had Jen Abel and Stephanie motherfucking Jones ready, Lively and Wayfair, and Popcorn Planet versus Lively, and now they're all shut down. But I won't give up. I'm getting you this information all day, okay? There's always workarounds. I was able to download it from somewhere else. I don't know what's happening with Court Listener. Hopefully it's because they're so busy uploading all of the documents, okay? We'll see what happens there. So this is the order coming in from the Florida federal judge. It's in the Middle District of Florida, Tampa Division. Please brace yourselves. Under Rule 45D3 Federal Rules of Civil Procedure, Popcorn Planet Inc. moves to quash a subpoena for documents served by Blake Lively, who responds in opposition. Documents 1 through 2 and 8 through 12, because Popcorn Planet fails to establish that the privilege applies or otherwise waived the privilege and fails to demonstrate an undue burden. The amended motion to quash is denied. This matter relates to Lively versus Wayfair Studios LLC, which is a pending in Southern District in New York. Lively sued in December of 2024 and alleged that during production of the film It Ends With Us, she experienced sexual harassment and an organized campaign of retaliation led by her co-star, Justin Baldoni. According to the complaint, Baldoni engaged crisis manager Melissa Nathan to help Baldoni get ahead of the narrative and mitigate bad press generated by Lively's complaints. The thing is like, oh gosh, don't get me started. It's just so crazy because she hadn't complained during the entire press tour. She didn't say nothing about anything happening on set. So why would they engage crisis PR over something that wasn't happening? Do you know what I mean? What they were doing was defending themselves because a lot of stuff was coming out from Blake Lively's camp about lingering on a kiss and fat shaming. Okay, that's the only thing that was coming out. But let's just continue because I'm going to get real worked up as it goes on. The strategy allegedly include third-party advocates willing to provide a potential quote or engage with reporters on behalf of Baldoni and others, and the seeding of content on traditional and social media platforms. In an amended pleading, Lively alleges that this campaign continued after the filing of her complaint. If she was allowed to now with Judge Lyman, she would be saying the exact same thing. She thinks it's still ongoing, and he put a pause to it. And now they're only allowed to get information all the way up to February 18th, because after February 18th, the water is a little muddy. You know, you can't just keep claiming retaliation. It's actually part of a litigation strategy at that point. So from February 18th ongoing to today, she's not allowed to get anything else for retaliation. According to Lively, the defendants directly engaged with media platforms to overwhelm and confuse the public's misunderstanding of Lively's allegations and to drive negative sentiment against Miss Lively and anyone who supports her or speaks out against Mr. Baldoni. Confuse us about your allegations? We didn't know nothing about nothing in August of 2024. What is you talking about? Unless she's talking about after her complaint, which is still wild because all we had to do was read Wayfair's complaint, which came out days later. Lively further alleges that this campaign involved statements by the defendant's lawyer, Brian Freeman, who regularly issues inflammatory content to media outlets and who says anything, whether true or false, that will harm Miss Lively's credibility and intimidate others from speaking. Lively alleges that Mr. Freeman's statements were published with actual malice because the defendants know that the core narrative advanced by Mr. Freeman, that Miss Lively fabricated made-up sexual harassment claims to seize control of the film, is false. Why would Brian Freeman think they're false when you have, I would say, 85% of content creators also thinking they're false, with like so many more people watching and tuning in, and they all have their opinions that they're false? Because girl, give us something. A text message, a text exchange, an email, a letter, an actual grievance, like something, right? So now she's saying that Brian Freeman, he got a hold of content creators and it's false what he's saying because he knows it to be false. Girl, is you okay? The defendants allegedly seeded social media content with content creators online chat sites like Reddit and into publications with small audiences and lax editorial standards. The team would then amplify that content by sharing them with large publications. Among her claims, Lively alleges defamation and defamation per se by Baldoni and others through their agents, including Brian Freeman, based on their publishing of false and defamatory statements about Lively. It's about to get worse. Andy Signor is the founder and CEO of Popcorn Planet Inc., which he describes as a publicly accessible news and commentary channel with nearly 1 million subscribers and a large daily viewership hosted on Popcorn Planet's designated YouTube channel. Signor describes himself as Popcorn Planet's main host, investigative reporter, and paid employee. Signor claims extensive experience in journalism and entertainment news reporting. Lively subpoenaed Popcorn Planet for 7 categories of information related to the underlying action. The subpoena called for a response by July 23, 2025. On July 25, 2025, Signor moved to quash the subpoena, which he followed with an amended motion to quash on July 29th. In the amended motion to quash, Popcorn Planet argues that the subpoena seeks material covered by the journalist's privilege, that Lively cannot overcome the privilege, and that the subpoena imposes an undue burden because Lively could obtain the documents from the defendants. Lively responds that the subpoena does not seek privileged material, that even if it does, Lively can overcome the privilege, and the subpoena imposes no undue burden. Rule 45D, applicable law. Rule 45D3A, Federal Rules of Civil Procedure, requires quashing or modifying a subpoena on timely motion if the subpoena requires disclosure of privileged or other protected matter. If no exception or waiver applies under Rule 45E2, a person withholding subpoenaed information under a claim of privilege must 1. Expressly make the claim, and 2. Describe the nature of the withheld documents, communications, or tangible things in a manner that, without revealing information itself privileged or protected, will enable the parties to assess the claim. The party invoking a privilege bears the burden of proving it. A blanket assertion of privilege is insufficient. Rather, a party asserting privilege must establish the privilege for each document withheld. Rule 501, Federal Rules of Evidence, provides that the federal common law privilege applies unless the U.S. Constitution, a federal statute, or a federal rule provides otherwise. In a civil case, state law governs privilege regarding a claim or defense for which state law supplies the rule of decision. In a civil case, state law governs privilege regarding a claim or defense for which state law supplies the rule of decision, such as a case arising under 28 U.S.C. However, federal law of privilege provides the rule of decision in a civil proceeding where the court's jurisdiction is premised upon a federal question, even if the information sought is relevant to a pending state law claim. Here, the underlying complaint invokes both federal question and diversity jurisdiction. But as to the journalist's privilege, the application of either the federal common law standard or Florida law will yield the same result. So deciding between the 11th Circuit and the Florida standards is unnecessary. The 11th Circuit recognizes a qualified privilege for journalists, allowing them to resist compelled disclosure of their professional news gathering efforts. This privilege shields reporters in both criminal and civil proceedings. A party can overcome the privilege by demonstrating that the information is relevant and unavailable elsewhere, and that a compelling need supports disclosure. This standard applies even when the source of the information is not confidential. Under Section 90.5015, Florida statutes, a professional journalist has a qualified privilege not to be a witness concerning and not to disclose the information, including the identity of any source, that the professional journalist has obtained while actively gathering news. This privilege applies only to information or eyewitness observations obtained within the normal scope of employment and does not apply to physical evidence, eyewitness observations, or visual or audio recording of crimes. Section 90.5015B defines a professional journalist as someone who regularly engages in collecting, photographing, recording, writing, editing, reporting, or publishing news for gain or livelihood, and who obtain the information while working as a salaried employee or an independent contractor for a newspaper, news journal, news agency, press association, wire service, radio or television station, network, or news magazine. It specifically excludes from its coverage book authors and others who are not professional journalists, holding that a qualified reporter's privilege exists in Florida and that such a privilege extends to both confidential and non-confidential information gathered in the course of a reporter's employment. Although Section 90.5015 applies to professional journalists only, the statutory language encompasses journalists working outside of traditional print media. Finding that an online-only news outlet and its reporters successfully invoked the privilege because the outlet qualified as a news agency, news journal, or news magazine that wrote and published news articles on its website. That was a case that he was referring to. Similar to the 11th Circuit precedent, Section 90.5015b requires that a party seeking to overcome the privilege show clearly and specifically, 1, that the information is relevant and material to unresolved issues that have been raised in the proceeding for which the information is sought, 2, that the information cannot be obtained from alternative sources, and 3, that a compelling interest exists for requiring disclosure of the information. I mean, keeping sources away from Blake Lively and Ryan Reynolds should be enough, but it is what it is. 3, analysis. A, Popcorn Planet fails to show that the journalist's privilege applies and otherwise waives its claim to privilege. Okay, this is where it's going to get juicy. Okay, this is where you're probably not going to agree. Because Andy Signor is a very well-established news outlet figure, mainstream media. I mean, he's been doing it since Johnny Depp. He's been on so many shows. He's won so many awards. I mean, his resume speaks for itself. So to say that he is not entitled to the journalist privilege is a little bit wild. Signor formed Popcorn Planet on June 20th, 2022 as a Florida for-profit corporation for the purpose of media production. He reinstated the corporation on October 8th, 2025 after an admin dissolution in 2024. Signor claims that he is an investigative reporter and receives a salary from Popcorn Planet. Signor describes Popcorn Planet as a publicly accessible news and commentary channel and himself as the show's main host. Popcorn Planet's channel is an account on the website youtube.com through which Signor publishes content. Signor describes the channel's content as news videos, some of which feature legal experts to comment on high-profile court cases involving celebrities. Signor claims that he is unquestionably entitled to invoke Section 90.5015 Florida statutes, as well as the common law federal privilege. Signor asserts that Florida courts have already determined that the statutory journalist privilege under 905015 applies to internet-based entities as long as they report the news. However, none of the cases cited by Signor determines as much or contains significant analysis of the statutory language. Similarly, Signor claims that he is a professional journalist as defined in Section 905015, but again, offers no analysis on the statutory language and concludes without explanation that Popcorn Planet satisfies that language. Finally, Signor claims that the content published by Popcorn Planet constitute news because that content is information of public concern, namely in the categories of entertainment, culture, and current events. To qualify as a professional journalist under Section 905015b, Andy Signor must regularly engage in the collection and publication of news while working as a salaried employee or independent contractor for a newspaper, news journal, news agency, press association, wire service, radio or television station, network, or news magazine. Yet, Signor says nothing about how Popcorn Planet fits within the meaning of these terms. For example, Popcorn Planet concludes without analysis that Popcorn Planet is the type of employer contemplated in Section 905015. However, a YouTube channel such as Popcorn Planet is clearly not a newspaper or news magazine, under a plain and ordinary meaning of those terms. Neither does Popcorn Planet readily fit the terms news agency, press association, wire service, radio or television station, or network. That leaves news journal, which also appears to exclude from its plain and ordinary meaning a YouTube channel. Oh, this is so annoying because he gets more views than any news channel out there, including probably TMZ. I mean, anyone, right? And he's been doing it forever, ever. Even if Popcorn Planet could muster a definition, even if Popcorn Planet could muster a definition broad enough to cover its YouTube channel, any interpretation must consider the context in which the term appears. Section 905015 is precise and clearly intended to exclude certain types of media, as evidenced by the exclusion of book authors and others who are not professional journalists. The definition of professional journalists includes within its scope professional news organizations, which are distinguished in part by the exercise of editorial standards and control. Nothing submitted by Popcorn Planet suggests that its show practices the editorial standards normally associated with a professional news organization. I would like to know what standards he's really talking about, because in the past month only, how many lies, how much misinformation, how many things have we saw from news organizations that were completely wrong? Furthermore, although Signor investigates entertainment news and creates content, his position at Popcorn Planet is not the type contemplated in section 905015. Signor says that he is employed by and receives a salary from Popcorn Planet, but he is also Popcorn Planet's owner, founder, and CEO, the host, director, editor, and main producer, as well as the registered agent of the company, the addresses for which consist of a USPS mailbox and a private residence according to the Florida Department of State. Thus, Signor is self-employed, and Florida courts have historically held that journalist privilege applies to journalists employed or hired by traditional media outlets. Additionally, as explained during the first hearing on Popcorn Planet's motion, whether the privilege applies depends not only on whether Signor is employed as a professional journalist, but also on whether he was engaged in news gathering at the time that he obtained the information. Even if Signor is employed as a professional journalist within the meaning of the privilege, Signor is not necessarily engaged at all times in professional news gathering, in the same way that a lawyer is not always engaged in attorney-client communication or working in anticipation of litigation. Signor cannot assert a blanket claim of privilege over his activities, but rather must assert that privilege on a document-by-document or item-by-item basis, as would any holder of a constitutional or statutory privilege. Blanket assertions of privilege before a district court are usually unacceptable. Instead, an attorney must present himself with his records for questioning, and as to each record elect to raise or not to raise the defense. Furthermore, Rule 26 and 45 require timely and express claim, as well as a disclosure of information sufficient to support his claim. Here, Lively served the subpoena on July 3rd, 2025, and Popcorn Planet moved to quash on July 25th, 2025, 2 days after the time required for compliance. As of October 22nd, 2025, Popcorn Planet has not produced a privilege log identifying responsive but privileged documents and had not sought an extension of time in which to do so. After requiring the parties to confer about the scope of the search for responsive documents, on October 31st, 2024, an order required Popcorn Planet to produce a privilege log no later than November 5th. Popcorn Planet moved for an extension of time and attached a preliminary privilege log to its motion. During a November 7th, 2025 status conference, I explained to Popcorn Planet that the privilege log was inadequate. For example, in one entry, the log identifies a text string spanning from January 1st, 2025 to June 24th, 2025. The description, that entry along with every other entry, is a vague conclusory statement essentially saying that the item is privileged, which provides little basis from which to evaluate the claim of privilege. In response, counsel for Popcorn Planet argued that it was nonsense or absurd to suggest that he had to log or itemize each and every text message subject to the privilege. Consistent with counsel's position that the law does not require particularity and that Popcorn Planet can claim the privilege categorically, the final privilege log filed by Popcorn Planet contains no changes except for the addition of 2 items. Counsel for Popcorn Planet is incorrect on the law, and he fails to show that the subpoenaed communications were privileged. Popcorn Planet produced no privilege log until ordered to do so 3 months after receiving service of the subpoena. Thus, the Popcorn Planet failed to timely provide a privilege log, and despite repeated opportunities to correct this omission, Popcorn Planet failed to produce a privilege log with sufficient particularity to assess the privilege claim. This results in a waiver of the privilege. When a party provides an inadequate or untimely privilege log, the court may choose between 4 remedies. 1. Give the party another chance to submit a more detailed log. 2. Deem the inadequate log a waiver of the privilege. 3. Inspect in camera all of the withheld documents, and 4, inspect in camera a sample of the withheld documents. An in-camera review of documents included in the privilege log demonstrates the problem with Popcorn Planet's generic and conclusory privilege log. For example, item 4 on the privilege log is a 6-month-long 89-page text message conversation between Signor and a defendant in the underlying lawsuit. Y'all see that? That's crazy. So he's saying he was talking to someone for that long, and it's a defendant in the underlying lawsuit. I'm thinking probably Melissa Nathan, crisis manager, would be my best guess. I don't know. Item 4 on the privilege log is a 6-month-long 89-page text message conversation between Signor and a defendant in the underlying lawsuit. As one would expect, the conversation contains some information that is clearly irrelevant, unresponsive, and not privileged. The text message conversation constitutes the bulk of the material in the initial privilege log, which contains a mere 142 pages. Yet, the log nowhere specifies the number of individual messages, pages, or specific exchanges to which the privilege allegedly applies. The final privilege log contains only 2 additional items, which suggests that the final universe of documents is much longer than 142 pages. Thus, Popcorn Planet cannot plausibly claim an undue burden in having to separate these documents into their relevant and purportedly privileged parts. Even if the inadequate privilege log caused no waiver, Popcorn Planet's production of documents has. A comparison of documents included in the in-camera inspection with those produced to Lively reveals no discernible substantive difference. Items 5 through 17 and 19 are inquiries by individuals associated with Popcorn Planet seeking comment from people involved in the film who provided no substantive response. So, I mean, she even wants the communications of people that he just reached out to, even if they didn't answer back. Why? These emails are similar in content and characters to the emails produced by Popcorn Planet to Lively. Yet, Popcorn Planet provide no information about why some inquiries are privileged and others, similar inquiries, are not. Accordingly, I find that Popcorn Planet fails to establish that the items responsive to the subpoena are protected from disclosure under the journalist privilege. Even if Popcorn Planet established that the privilege applies, Lively overcomes it. Isn't that nice? Even if Popcorn Planet established that the items sought by Lively fall within the journalist privilege, Lively can overcome it. The requests in Lively's subpoena are directly relevant and material to her claim that the defendants in the underlying action orchestrated a campaign to defame her with help of third parties who created disparaging and false content. Furthermore, an in-camera review reveals that the responsive materials are directly relevant and material to Lively's claims. So obviously Andy has something with her claims, so that will be very interesting because she's gonna get everything. Unless he fights it and gets away and is able to appeal or fight it in some way. Lively further establishes that she tried to discover this information from the defendants and so, to some extent, has been unable to obtain these materials from them. Lively demonstrates a compelling need because these materials go to the heart of the matter. That is the primary theory underlying Lively's defamation claim, explaining that the Florida law and the 11th Circuit direct courts to pierce the journalist's privilege in libel cases when a journalist is the defendant and where a plaintiff's need for the information goes to the heart of the matter. The subpoena imposes no undue burden on Popcorn Planet. Popcorn Planet argues that the subpoena imposes an undue burden because the subpoena seeks extensive document production and because Lively has not exhausted more direct avenues to obtain the requested information. This argument fails for several reasons. During the first hearing on Popcorn Planet's motion to quash, counsel admitted having not discussed the scope of the request or the attendant search with counsel for Lively. When given an opportunity to raise objections on the scope of the request in the subpoena, counsel for Popcorn Planet said, "I don't have a problem with the scope," and affirmed that his only concern was with privilege. Second, although the undue burden analysis under Rule 45 considers whether the materials are available from another more convenient source, nothing in Rule 45 requires a party to exhaust all other sources of information before pursuing third-party discovery. Even if required, Lively has attempted unsuccessfully to obtain the same communications from the defendants in the underlying case. Accordingly, Popcorn Planet fails to establish that the subpoena imposes an undue burden. Conclusion. Accordingly, the amended motion to quash is denied, and the initial motion to quash is denied as mute. No later than December 17th, the movant Popcorn Planet must produce all responsive material to Lively, including every item contained in Popcorn Planet's privilege log, as well as the attachments to those items. To the extent necessary and not already covered by an order in the underlying action, the parties may propose a stipulated protective order governing the handling of the information. Oh my gosh, my nose is doing that thing where it gets really itchy again. Maybe it's my makeup. I don't know. But there you have it. It looks like, yeah, I don't know. It's very interesting that he has so much information with defendants. That's going to be interesting. That's definitely something that Blake Lively is going to run with for a very long time. I hope that there is a protective order in place. I hope it's attorney eyes only. I hope Ryan Reynolds, who's not even a freaking party anymore, okay? He's not a party in this case, can't get his hands on it or his eyes on it, and I hope Blake Lively can't see it either. It should all be attorney eyes only, especially when it comes to the documentary, when it comes to obviously having conversations with either Brian Freeman, Melissa Nathan, or any of the defendants. Blake Lively will be able to get those communications, but I think they are definitely going to fight this ruling, and they're going to bring it to Judge Lyman, and I believe that they should, because it's very untimely that she's still filing this. I mean, we already know that Stephanie motherfucking Jones was just denied because she tried to serve a subpoena way late in the game. So the fact that he has to provide everything, I think, should only go up until February 18th. So it should be from August 2024 to February 18th. And we'll just see what happens next. But this is a really big bummer. I mean, I feel like it was, kind of biased against Popcorn Planet and Annie Signor, in my opinion. But you let me know what you think. In the next video coming up, I'll be talking about the New York Times. Wayfarer has replied back to them. And then we'll keep rolling it out as we go. I hope you're having a great day, and I will talk to you soon. I love you so much. Bye.